So the DOJ and AG Bondi are now joining the fight against statewide concealed carry ban laws, which are currently in front of the Supreme Court. This is some big news, so we need to talk about what is happening. Now, really quick before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. That of course helps the channel to grow. Double check to make sure YouTube has not unsubscribed you because they love to do that. And then just drop a positive comment down below because that helps to tell the algorithm that you appreciate this type of 2A content and it should share it to more people. So as I mentioned in the intro, in this video, I have some big news for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within those states. You may recall that recently the Ninth Circuit issued a decision on multiple concealed carry laws, which were passed in direct response to what the Supreme Court said in the Bruin decision. One of these cases was the California SB 2 case, and then also we have another case out of Hawaii which deal with trying to ban concealed carry. The case that is currently seeking Supreme Court intervention is a case out of Hawaii called Wolford versus Lopez. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states could actually put in place catch-all public carry bans and that those would be permissible under the Second Amendment. Well, now to the surprise of many, the DOJ and the AG Bondi and essentially the United States have stepped in and are actually supporting this challenge against the state of Hawaii. They recently filed an amicus brief to the Supreme Court, and they argue that it is finally time for the Supreme Court to review these concealed carry ban issues, and they need to actually respond to these states defying Bruin. They also surprisingly push for the court to correct some of the ongoing lower court defiance and to step in when it comes to issues of rifle magazine bans. This, of course, is good news, and it shows that the administration is taking these issues serious and that they're stepping in to actually support these challenges at the Supreme Court level. Now, the case we're talking about, like I said, is out of Hawaii. It's the Wolford case, and it deals with Hawaii's new laws that they passed in direct response to Bruin. This law in the state of Hawaii, like others, tried to add more restrictions to concealed carry and essentially created a default rule where individuals could not carry at public or private properties that are owned by property owners without getting the express permission by the property owner. This new law sought to operate in a way that Hawaii could still ban concealed carry statewide, even after Bruin. Now, prior to Bruin, the state of Hawaii had, operated kind of as a may issue scheme. So in operation, they said it was may issue, but essentially the state of Hawaii in a lot of localities simply did not issue permits. In fact, in 2018, the Ninth Circuit noted that Hawaii had issued only 4 concealed carry licenses to private citizens in essentially 18 years, and that in one county, not a single concealed carry license had ever been granted. So although it operated as may issue, it simply was not issuing permits. However, in Bruin, the Supreme Court held that the Second Amendment guarantees a general right to public carry of arms for self-defense, and that may issue schemes were simply unconstitutional. So they struck those down in Bruin, and states had to go back to the drawing board, and they were supposed to go to at least shall issue. However, Hawaii, in response, like other states, decided to pass new laws, and Hawaii passed Act 52, which is a statute that overhauled the state's concealed carry laws and really made it even worse. They put in place a hyper-restrictive system that essentially still banned concealed carry. Because of this, plaintiffs along with 2A orgs sued the state of Hawaii to strike down this new law. Now, on review, a federal district court issued a TRO, which was later then converted to a preliminary injunction against this law. In that decision, the district court blocked the private property rule as likely a violation of the Second Amendment, and they found that it was inconsistent with Bruin. This case then was appealed by the state of Hawaii up to the Ninth Circuit, and the Ninth Circuit reviewed this case along with the California carry ban. And on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction which was issued by the district court. The Ninth Circuit relied on older restrictions on hunting on private property to support this type of statewide carry ban. So they relied on really old history, which, you are supposed to look at history dating back to 1791, but they draw an analog from restricting people from hunting on your own private property. They tried to use that to justify a statewide carry ban. Now, after that, the plaintiffs asked for the Ninth Circuit en banc panel to review the decision of the 3-judge panel in the Ninth Circuit, but that en banc panel review was denied. Now, in that denial, you did have dissents from judges like Van Dyke, and he was joined by 5 other judges on the Ninth Circuit who said that the Ninth Circuit en banc panel should have granted review to this case. Now, in that dissent, the judges stated that this default property rule effectively nullifies the Second Amendment rights of Hawaiians and has no grounding in the historical record. This horrible law and the decision by the Ninth Circuit has now led the plaintiffs to seek Supreme Court review. The question presented to the Supreme Court for review is whether the Second Amendment allows a state to make it unlawful for concealed carry license holders to carry firearms on private property open to the public without the property owner's express authorization. Now, this case theoretically had a long shot of getting Supreme Court review since it's still in an interlocutory preliminary injunction stage, and the Supreme Court has categorically denied these type of cases. However, now things have drastically changed because the United States, through the AG and Pam Bondi and the DOJ and the new Solicitor General, they have stepped in support of the plaintiffs here, and they're saying that the Supreme Court should review this Hawaiian case. This is huge because you have the federal government now pushing for Supreme Court review and essentially asking for the Supreme Court to strike down this state carry ban. Now, in the recent amicus brief filed by the United States government, they state that near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary law-abiding citizen has a general right to publicly carry arms for self-defense, just as states may not limit the right to those who show a special need for self-defense. States may not limit the right to those who aimlessly wandered the streets. Here, the government is pointing out that the historical justifications put forward by the Ninth Circuit and used as a justification to support the catch-all property ban should have really been found insufficient. However, the Ninth Circuit kind of stayed true to twisting their justifications to uphold this ban and essentially go against Second Amendment precedent. Now, one of the interesting things with this brief is that the United States government pushes for the Supreme Court to take this case at this interlocutory posture to still review it even though it deals with a preliminary injunction. They argue that the preliminary injunction posture in which this case arises should not deter this court from granting review. The Court of Appeals did not decide this case in haste. To the contrary, it issued an 81-page opinion nearly a year after petitioners appealed. The court's decision also turned on the merits. The court explained that it need not consider the equities because petitioners were not likely to succeed in challenging the default rule. And since the court's merits analysis all but foreordains the final outcome, further proceedings in the lower courts would serve no useful purpose. This court often considers constitutional issues in the context of preliminary injunction proceedings. No sound basis exists to treat Second Amendment issues differently. Now, this is important because we have seen the Supreme Court step in on other legal issues at an interlocutory preliminary injunction stage, but they have refused to do so when it comes to the 2A context. Here, the United States government is asking for these 2A cases to be treated the same way as the Supreme Court has treated other legal issues. Now, the last thing I want to point out when it comes to this amicus brief is the fact that the federal government also snuck in a mention that it's finally time for the Supreme Court to also review issues when it comes to, rifle bans and magazine bans that are put in place by various states. They state in the brief that Rahimi began the process of clarifying who may possess arms. This case affords an opportunity to begin addressing where arms may be carried, and the court should, in an appropriate case, also provide a framework for evaluating what types of arms people may possess. The court's consideration of those important questions would help lower courts seeking to interpret the Second Amendment, legislators seeking to comply with the Constitution, and most important, ordinary Americans seeking to exercise their fundamental right to possess and carry arms for lawful purposes, such as self-defense. Now, this statement here signals that the Trump administration is very aware that you have cases like Snope and Ocean State Tactical currently pending in front of the Supreme Court. And those cases deal with a statewide ban on rifles and a statewide ban on possession of magazines that hold more than 10 rounds. This is showing that the Trump administration is aware of those cases and they potentially want the Supreme Court to review those issues. All in all, this is great to see coming out of the Trump administration, and in some ways it's also kind of weird to finally see the federal government filing briefs in support of these pro-2A cases that are challenging various state bans on, concealed carry, on rifle bans, magazine bans. It's kind of strange to see the federal government filing these briefs and pushing the Supreme Court to review these issues, but again, it's a good sign coming out of the administration. I think now there is a stronger chance that the Supreme Court could grant review to this carry permit case and maybe other cases like Snope and Ocean State Tactical. The conservatives on the Supreme Court now have a strong signal from the administration that the administration is in support of striking down these statewide carry bans and also potentially in support of striking down these statewide rifle bans and magazine bans, and that they wouldn't get pushback from the administration. Ultimately, you still need the Supreme Court to have the votes to actually grant review to these cases, and usually they won't even grant review to the cases unless the conservatives, potentially pro-2A justices, know that they have enough votes to rule in the way that they want. But overall, it's great news coming out of the Trump administration that they're actually filing an amicus brief, pushing the Supreme Court to finally address the statewide concealed carry ban issues, and also mentioning in that same brief that they want the Supreme Court to finally address other issues like rifle bans and magazine bans. So now we're going to see how this plays out, and as we get more information, as this develops more, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.